Thank you for taking the time to view this video produced by the law firm of Kuczek & Associates, a firm that limits its practice to estate planning. It's our hope that after you invest your time watching this video, that you'll feel it's an investment not only for you, but in the future of your family. This video is not meant to take the place of a consultation with an individual attorney. You should always plan your estate one-on-one with a licensed attorney. Whether you seek out our advice or the advice of another firm that limits its practice to estate planning, we encourage you to take action, make an appointment, and plan your estate now. I'd like to start out this presentation by asking, do you have small children now, or have you ever had small children? Or if you don't, how many of the rest of you know somebody that did? Well, I think I've basically covered anybody. The point I'm trying to make is that whether you have small children or whether you know somebody that did, one thing you know for sure is that somewhere along the line you've got to get away from it all. And what does that mean? Well, that means you've got to leave behind a babysitter. And with that babysitter, you're going to leave some instructions. Now, some of us will leave some fairly bad instructions, to be very honest with you. In fact, we might be so happy to leave, we just bolt out of the house and we don't tell the babysitter anything. But most of us would do a little bit better than that. We'd at least tell the babysitter, we're going out to dinner, and we'll be at Carson's. We'll be back around 6:30. But some of us might even go farther than that. We might say we're going out to dinner, where we're going to be. And by the way, in case you can't get a hold of us, I'm going to leave you this piece of paper here. And you see on here, there's a list of names. And one of those names is my sister. You can get a hold of her in case you can't find us, and she'll be able to tell you what to do. The great thing about it is, though, no matter how good or bad your instructions are, you're out to dinner and you remember you forgot something. So what do? Well, you get up from the dinner table, you pop a quarter in the old payphone, and you call home. You tell the babysitter, make sure that my daughter Susan gets her homework done. And my son John, there's an awful program that comes on at 7:30. Make sure that he doesn't see that. That's the great thing about being alive. We can always call home and change our babysitting instructions. But what kind of instructions would you want to leave behind if you were going to go away forever? And that's really what we're talking about when we talk about estate planning. We're talking about leaving behind a set of instructions. But the fact of the matter is that most of us will leave a more complete set of instructions behind for a babysitter than we have for all those things that we've spent our entire life accumulating. Well, in our firm, we believe that to have a good estate plan means leaving behind good instructions. And in order to have good instructions, we believe some basic things. The first thing that we believe is that you should control all your property. That might seem very basic. But what you're going to learn during this video is there are many circumstances, depending on the way you currently own your assets, where you can actually lose control of them. And wherever possible, we want to enhance your level of control. Now, the second thing we want to make sure of is that you not only give what you want to who you want. I mean, to be real honest with you, any simple will could do that. But more importantly, we want you to be able to do it the way you want and when you want. So for instance, if it's your intention to make sure that a child gets college education with the money that you leave them when they turn 18, and you really don't want it spent on fast cars or gambling or whatever, you ought to be able to accomplish that. And then lastly, let's do all of this at the lowest possible cost. And by that I mean minimize all the possible attorney's fees. And yes, I'm an attorney. We want to minimize those fees. All the possible court costs and all the possible taxes. Now you might think that that's an easy thing to do, but it really isn't. And the reason is because there's some real powerful barriers in our way. In fact, we'll call those evils today. And they're really going to be referred to during this video as the 3 evils of estate planning. And what are they? The first one's called living probate or disability probate. It's also known as guardianship or conservatorship. What you're going to learn about living probate is how it's a court proceeding that takes over if you become disabled, and how it causes loss of control over your assets while you're alive. Now, the second kind of probate is called death probate, and usually most people are familiar with this kind of probate. You might not know exactly how it works, but you probably know that it has to do with attorneys and judges, courtrooms. There's a lot of cost and time involved, and all those things are true. But what you're going to learn during this presentation is how it causes loss of control over your assets through the probate process. And then lastly, we're going to talk about death taxes. Now, these are the certain kind of tax that are imposed upon you for the right to leave your assets to someone after you die. Someone once told me it's the government's last chance to pick your pocket. Now, how are we going to talk about these things? There's so many different areas of the law that come into play. But I don't know. If you're like me, You don't like to go and turn on a tape or hear a speech and have somebody start spouting out IRS code sections to you. 3026-B4, 1 paragraph 2A3. We're not going to do that. And even though areas like trust law and property law and debtor-creditor law, so many different areas of the law come into play, but we're not going to talk about it that way today. Today we're going to talk about two people, Bob and Pam. Now, Bob and Pam are married and they have a $600,000 estate, and they own all of their assets equally. Two questions might immediately come to mind, and the first of those is, Ted, I have either more than $600,000 or less than $600,000. Is this going to apply to me? The answer to your question is yes. We're just going to use $600,000 as an illustration, but before we're done, we'll do an estimate of what your probate costs and your federal estate taxes would be no matter what size your estate is. The other question you might have is, gee, I'm single, widowed, or divorced. Is this going to apply to me? Again, the answer is yes. And in fact, when I plan for a single, widowed, or divorced individual, in every circumstance, I found that those three evils of estate planning will attack that kind of an estate even harder than they will a married couple's estate. And actually, we'll see what happens after Bob passes away. Obviously, Pam would be a widow at that point in time, and you'll be able to see exactly how it would affect you. And that would also apply to you if you're single or divorced. Now, Bob and Pam have some pretty common estate planning goals. They want to leave everything to the surviving spouse. And then on the death of the surviving spouse, they want to leave everything to their two children in equal shares. Now, their two children you need to know a little something about. The first one's Susan. Susan is absolutely the perfect child, and I'm sure that you know somebody like this. Now, she's never done anything wrong, right? She always does the right thing. Now, John, he's on the other end of the spectrum. And Bob and Pam, well, they love John just as much as they love Susan. John just took a wrong turn, I think back sometime in the 1960s, and he hasn't quite found the road back yet. Now, I don't need to know right now if you have somebody like that in your family, but you need to think about that. Because when you're planning for those different children, and you want to plan for them equally, you're going to want to know what those differences are so that you can plan your estate accordingly. Now, Bob had a heart attack. Fortunately, he survived. And when he came out from under the anesthesia, he thought about planning his estate, which, by the way, is not all that uncommon. Now, the first thing Bob thought about doing was nothing. I mean, to be very honest with you, that's what he's always done, and that's what most Americans do. But I'm going to take it on faith here that you're not listening to this tape because that's what you think you want to do. Doing nothing will cause the maximum attorney's fees, probate costs, and federal estate taxes. So, we'll spend the rest of the tape talking about three other very common options, and the first of those is holding assets in joint tenancy. Now, joint tenancy is a legal fiction created by some magic words that lawyers use. If you're married and you own real estate, you probably have your house titled something like this: husband and wife as joint tenants with rights of survivorship, not as tenants in common. Now, when you see that kind of language on your deed, you know that you have a joint tenancy. What you probably don't know about joint tenancy is how, in my opinion, it's one of the most dangerous ways that anyone could own an asset because of the possibility for loss of control during the lives of the joint tenants. Now, the other option that we'll look at is a simple will. Now, when I say simple will, what I'm talking about is a will that basically leaves everything to the surviving spouse and then splits it between the kids in equal shares. I often refer to this as an I love you will. Honey, I love you, I'm going to give you everything, you'll give everything to me, and when we're both gone, we'll give it all to the kids. What you probably don't know about a will, however, is that it's literally your ticket into the probate court, and how loss of control ensues when you get involved in the court probate process. Now, the last option that we'll look at for Bob and Pam is creating a living trust and using a living trust as a vehicle for owning property during their lifetime, transporting that property throughout their life, and eventually distributing that property to their loved ones both the way they want and when they want. Now, let's talk a little bit more about joint tenancy. The rule of joint tenancy is really quite simple. Whoever lives the longest gets it, whether that's 1 second, 1 minute, 1 week, or 1 year. But what you probably don't know about joint tenancy, which causes loss of control, is what's called the 100% ownership feature. You see, the law says that in this situation, Bob owns 100% of each joint tenancy asset, and Pam also owns 100% of that same joint tenancy asset. Well, gee, Ted, last I remember from math class about 1 million years ago, you can't have 200% of the same asset. You're right. And it's the conflict between the legal definition of joint tenancy and the practical application that caused loss of control over joint tenancy assets during the lives of the joint tenants. For right now, all you got to remember is whoever lives longer gets it all. Let's talk a little bit more about a simple will. What is a simple will? Well, it's a set of instructions directing how your assets should be disposed of at death. Now, if you think about it though, what's the very first thing that has to happen before a will can take effect? Well, you have to die, right? Now, the flip side of that is, if you have to die first, well, then your will can't help you do anything to protect you while you're alive. And in fact, during your lifetime, your will is a worthless piece of paper. It springs to life only upon your death. And at that point, it has meaning in only one place on the planet. That's a probate court. It's literally your set of babysitting instructions, and you've appointed the judge in the probate court, the babysitter over your estate. Now the problem is, the judge has a whole other volume of rules that he needs to follow. That volume of rules is called the Illinois Probate Code. And it's the rules that are contained within the Illinois Probate Code that can cause loss of control over your estate after you die. Let's say that Bob becomes mentally disabled. He goes into a coma, or he has Alzheimer's disease. I mean, who's going to manage Bob's property? Well, we'll look at the joint tenancy and the simple will together here. And the reason that we're going to do that is because really they operate exactly the same way. We encounter the first evil of estate planning, which is living probate or disability probate. Living probate, is also known as conservatorship or guardianship, it's defined as the court proceeding which is designed to protect the person who is mentally disabled. Now that's real important as we go forward, because who's mentally disabled now? Bob. What are some of the disadvantages of living probate? Well, it's expensive because there's attorney's fees and accounting fees. It's also time consuming because of the court reports and the record keeping. It's a humiliating experience. Now let's look at what happens to Bob and Pam when Bob becomes disabled. Let's say Bob is in a coma and he's laying in the hospital. Now, they don't expect him to die. In fact, the doctors fully expect him to recover. They just don't know when. Now, Pam is going back and forth from the hospital home, and every night she gets home, the house is kind of dark. It's seeming like it's getting bigger. It's harder to maintain. And maybe it's reminding Pam of things that she just kind of wants to put behind her. For whatever reason, let's say that Pam wants to sell that piece of joint tenancy real estate. Can she sell it? Well, the answer is no. Why not? Well, because Bob can't sign with Pam. And remember, Bob's name is on the deed as well. So what does Pam have to do? Well, she's got to get appointed as Bob's guardian or conservator. What does that mean? Well, she hires an attorney. Now that attorney is going to take her into court. And the first thing that the judge is going to do when he sees that attorney is he's going to say, oh, this is fine, Pam, but where's Bob's attorney? Well, Bob doesn't have one. He can't hire an attorney, so the court appoints an attorney to represent Bob. And who pays for that court-appointed attorney? You got it. It's the estate. Now, you've got two attorneys in here. And the reason there's two attorneys, by the way, is because the judge wants to make sure that Pam isn't trying to pull a fast one on Bob. Now, that might make sense in big criminal trials, but I'm not exactly sure it makes a whole lot of sense here. Well, at any rate, the attorney goes and interviews his client, and let's face it, I mean, Bob's not in very much of a talkative mood, so the interview is pretty short. But the fact of the matter is, most of us don't know people that go into lingering comas and expect them to live for a long period of time. Most of the time when someone goes into a coma, it's a prelude to death. So what's a more common type of disability? Maybe Alzheimer's, Parkinson's, or a stroke. One of these diseases that affects our right to think. And in fact, these diseases are becoming more and more prevalent. The statistics that I've read most recently say that by the time we reach the age of 70, 1 in 3 of us will have a mental incapacity before we die. And by the time we reach the age of 80, 1 in 2 of us will have a mental incapacity. So let's look at this, the more common situation. Okay, Bob has got the beginning signs of Alzheimer's, and he's starting to do crazy things with his investments, things he told Pam he would never do. And Pam needs to now take control of the estate. So again, she hires an attorney to go into court, and the judge appoints a court-appointed attorney to represent Bob. But now the interview with Bob is a little bit different, isn't it? The attorney goes up and says, Bob, I'd like you to read this. You see, your wife has filed a petition to adjudicate you incompetent. What that means is she wants to take control of all the assets away from you, and she wants to control them herself. What do you think, Bob? Is that a good idea? No. What's he liable to say? I mean, I've always taken care of these things my whole life. Make sure that she doesn't do that. I mean, I guess the point is that he might put up a struggle. But let's keep this simple. Let's say that Bob does not put up a fight, and he uses the court-appointed attorney. Now, what these attorneys need to do is prove that Bob is in fact incapacitated. Well, how do they do that? Well, the attorneys might think that Bob is incapacitated, but the bottom line is they're not competent to take the witness stand and testify about those kind of matters. Who is? Well, a doctor, right? Now, how many of you know of a lot of doctors that just love to run into courtrooms and get questioned by attorneys back and forth? Well, there are doctors that do it. They're called expert witnesses. The problem, again, of course, is that there's cost involved. And there might be expert witnesses on both sides of the case. Eventually, though, let's say that they do prove Bob does have Alzheimer's. He can't handle his financial affairs anymore. So now they need to pick the guardian. Well, Pam has applied to be the guardian, but there's no guarantee that she will be appointed as the guardian. The fact of the matter is, the older that Pam gets, the more likely she is not to be appointed as the guardian. And in fact, the state might appoint somebody from the guardian ad litem's office. Those are attorneys that work for the state, and they get appointed by the judge to represent specific individuals. Now, if one of those needs to get appointed, who do you think pays for it? That's right, it's the estate. But again, let's keep this simple. Let's say that Pam's been appointed as the guardian. Finally, and remember, all this started because Pam wanted to sell that piece of joint tenancy real estate. So she calls up her friend, the real estate agent, and he lists the property for sale. They bring her an offer. Can she just sign the offer? No, not yet. You see, she's got to have her attorney bring that offer into court because the judge is protecting whose interest? Bob's. That's right. And if the judge doesn't think that Bob's getting enough money for the property, well, then Pam can't sell it. But who's got the control here, I guess, is the point. Let's say that the judge lets Pam sell the real estate. So after all the cost of sale, she's left with, let's say, $100,000. She's got to invest that, right? Is she free to invest it wherever she'd like? No. She's got to invest in what's called court-approved investments. Now, let's say Pam gets all this money invested, and now she wants to spend some of it on Bob. Maybe she thinks that one of those trampolines or a Thighmaster would be good and get his circulation going. Well, can she just go out and buy one? Not without permission from the judge. You see, because the judge is protecting Bob's interest, and he wants to make sure that anything that's being spent on Bob is appropriate. Loss of control again. All right, but let's say Pam, she spends some money on Bob, and now she needs to spend some of that money on herself. Well, most of us think that when we own property in joint tenancy, that we could simply just spend half of the joint tenancy anytime that we want to. You remember the 100% ownership feature of joint tenancy, and the judge is protecting Bob's interest, which by law is thought to be 100%. So, if Pam needs to spend some of that money on herself, and the judge thinks that Bob is going to need that money somewhere down the road, he can protect Bob's interest, which is 100%, which in effect would freeze Pam out. At that point, Pam has to wait for something to happen to Bob or get special approval from the judge before she can spend money out of those assets. The bottom line is that every step of the way, Pam is having to account to the judge, keep records, and in fact, once a year she'll probably have to present an accounting to the judge. Now, this is going to go on for a period of time, but somewhere along the line we assume that Bob dies. Well, what happens then? Well, this time joint tenancy and the simple will, they act a little bit differently. You remember the rule of joint tenancy. Whoever lives a little bit longer gets it all, so everything goes immediately to Pam. But with all the other problems that Pam had with the joint tenancy during life, we have to really wonder whether or not it was worth it. Now, let's say that instead, Bob decided to plan with a simple will. Well, in that case, no distribution is made to Pam until the estate is probated. And that brings us to the second evil of estate planning, which is death probate. What is death probate? Well, it's the legal process of transferring assets to one's heirs. And kind of like when we started talking about living probate, it doesn't sound half bad until you get into it. There are a couple of primary purposes of probate, and the first of those is to pay off creditors. Someone once defined probate for me as a lawsuit that you file against yourself with your own money for the benefit of your creditors. And that's basically what it is. You see, when you die and your will is submitted to probate, the first thing the attorney has to do is file notice in a local paper. I'm sure you've all seen notice sections like this in the paper. What this one basically says is, hey, Bob died. If you think that he owes you any money, you've got 6 months to come and get it. And it's very easy to file a claim in Illinois. Now, once all those claims are finally taken care of, the final purpose of probate is to change the title of the assets into the names of the beneficiaries, or in this case, changing the house from Bob's name into Pam's name. Okay? What else happens in probate? Well, this is where you have your forum to resolve disputes. And this is, say there's a will contest. Hey, you know, Uncle Bob said that he was going to leave everything to me. And so he must have been crazy when he wrote that will, because it doesn't leave anything in there for me. So this is where the will contest happens. It's kind of like jumping on a slow-moving train. Probate's already moving along, and anybody can just jump on. A couple of other problems are paying off creditors, and we talked about that. We inventory and appraise all the assets, and then finally we distribute what's left of those assets to the beneficiaries. The problem is that it's expensive. There's attorney's fees, and I'm going to talk a lot in this tape about how attorneys calculate their fees. But there's also executor's fees, appraisal fees, filing fees, bond premiums. You know, this is really much like a leaky pipe. Every few feet, a couple of drops fall out. The problem is that by the time you get to the end of this pipe, there isn't as much there for your loved ones as you might like. Now, how do attorneys calculate their fees? There's two basic ways. The first one's called reasonable compensation. Now, isn't that a curious term as it refers to attorney's fees? What exactly does that mean? Well, someone once defined it for me as whatever the attorney can convince the judge that he ought to be paid. And evidently, Illinois doesn't like that, does like that idea, because we work under a reasonable compensation law. There are other states, however, that don't like those laws, and what they do is they limit the attorney's fees to a percentage of the estate size, and they say we're going to call that fair. But let's take a look at it and see if it really is. Let's say that you got to buy a house, and it's a $100,000 home. Now, chances are you're probably going to have to get a mortgage for that house, and let's just say that you can get a $99,000 loan. And if anybody knows where you can get a loan like that, please call my number and tell me where it is. But at any rate, what's the equity in the property? This does help us to prove an example. Well, it's $1,000, right? Now, you're an attorney, and you're calculating your attorney's fees as a percentage of the estate size. Are you going to calculate based on the $100,000 value, a percentage of that, or a percentage of the $1,000 value, the equity? Well, you got it. You're going to calculate on the $100,000 value. And in a state like California, where the probate fees can be 6.3%, a $100,000 piece of real estate would generate $6,300 in probate fees. Now, even if you know, this is with $1,000 worth of equity. But I submit to you, even if you own your house outright, is $6,300 a fair fee for transferring one piece of real estate? What are average probate fees? Well, the Wall Street Journal did research on the subject, and they said that the national average comes out to be 7.4%. And that's the number that we're going to use today. Now, many would say in this area that we ought to maybe use 15%. I've seen it in the neighborhood of 5%, some as low as 2%. As an average, though, for today, we're going to use that 7.4% figure. What are some of the other disadvantages of probate? Well, we talked about excessive costs, but there's also the time delays. An average probate proceeding is going to take somewhere between 9 months and 2 years. And I don't know about you, but when I'm grieving over the loss of a loved one, I kind of want to move on with my life and move past it. And yet, in probate, you're constantly getting a call from an attorney. Come in to sign one more paper, there's one more court appearance to make. It's kind of like pouring salt in an open wound. You want to move on, yet the probate holds you back. Generally speaking, my experience is 1 year to 2 years is not uncommon for probate to linger. It's also a public record. Now, my guess would be that you've probably never published a list or divulged to anyone a list of all your assets before. You've probably never even given anybody a list of all your debts, except maybe a banker when you had to apply for a loan, and that didn't feel too comfortable either, did it? But the bottom line is, when you look at probate, these things are public. If you want to know about the intimate financial details of any famous people that died in Illinois with a probate estate, or even unfamous people, all you have to do is go down to the probate court and ask to see a copy of the file. They have to give it to you. It's part of the public record. Oh, there's a couple circumstances where I suppose they might freeze them up, but by and large, they're open to the public. If you look in one of these files, and I have, the first thing you find in there is called an inventory. What's an inventory? Well, it's a detailed list of all the assets in that person's estate on the date of their death. So you find out if they had a 2-flat in Chicago or a farm in southern Illinois, their stocks or their bonds. If you look a little bit farther, what do you find? A detailed list of all the assets. So now you find out what the attorneys or the accountants were paid. You know, if they've got an outstanding subscription to a magazine, you're going to find out what the subscription was and how much was due and owing. But if that's not bad enough, one of the last things you're going to find in there is the final distribution. Now, what's that? Those are the names and the addresses, very often, of the individuals who received the property. So now you find out what the husband or wife got, children, grandchildren, who got the 2-flat in Chicago or the farm in southern Illinois. And very often, though it's never really required, sometimes the attorney will throw maybe even a social security number on there. Now, if that's not anything you want someone to know about you while you're alive, is it really anything you want someone to know about your loved ones after you've gone? Furthermore, there's probate in every state where real estate is located. So if you happen to have a summer home or a second piece of real estate or a commercial piece of property in another state, you've got further time, cost, and inconvenience, which comes because of additional attorneys, additional courts, and additional coordination between those states to run those probates together. That's what we call multiple probates. That brings us to the third evil of estate planning, which is death taxes. Now, there's two kinds of death taxes. The first one's called inheritance tax. Now, that's the tax imposed upon you by the state that you live in on the date of your death. And by the way, Illinois doesn't have those anymore. They were repealed a number of years ago. And so what we're really worried about in Illinois is the the federal estate tax. And there's a reason that we're worried about it. The federal estate tax rates start at 37%, and then they rise as high as 55%. Now, that's much higher than any personal income tax brackets. Now, there's also an exemption from those taxes, which you're probably familiar with, and that exemption currently rests at $600,000. Let's just take a moment now, because I told you we were going to help you estimate what your federal estate tax liability would be. What I want you to do is to start to create a list of the value of all the things within your estate and what they're worth today now, not what you paid for them. So if you have a house that you bought for $50,000 and it's now worth $100,000, well, you've got to value that at $100,000. Let's say that you bought some stocks for $5 a share, they're now worth $10. Well, you've got to value those at $10 a share. Also, put down some things that generally people forget about putting in. And that's the pay-on-death value of your life insurance policies. Not the cash value, and sometimes not even the face value, but what's it going to pay on death? Because it's the pay-on-death value that's going to be includable in the estate of the surviving spouse upon their death. Also, put in there any retirement plans that you might have, 401ks, IRAs, KEO plans, anything that would have a value into your estate upon your death, even though it's coming to you without income tax. And by the way, that's a problem as well, because you know that your IRAs and your 401ks, generally speaking, you haven't paid any income tax. That's actually a double whammy. We're not going to get into the income tax part of it today, but you need to know there's a double tax on those types of assets. Well, you've probably also got personal property. Those are things like automobiles, household furnishings, jewelry, furs, clothing. I mean, you need to add the value of those things in there as well. And I'm sure there's a lot of things, maybe annuities or other investments that I haven't mentioned. And you need to add all those things together. When you do that, you'll come up with the gross value of your estate. Now, the government does let you subtract out any debts that you owe. So you can take out your mortgage and take out any long-term debt or short-term debt that you have. And then you'll come up with the net value of your estate. Let's assume that the net value of your estate is $600,000. Well, you've got $600,000 that you can pass tax-free. There's no tax. But what if it's $700,000? Well, now you've got $700,000. You could subtract out the $600,000 credit. That leaves $100,000 subject to tax. And at the minimum bracket of 37%, that's $37,000 in federal estate taxes. Let's say that your estate goes all the way up to $1 million. Well, again, you subtract out the $600,000 value, you're now left with about $400,000. Well, that's going to leave you with about $153,000 in federal estate taxes. By the time you get to $3 million, you're at the 55% tax bracket, which means that you're giving more to the federal government at that point than you are to your family. Now, there's another thing that you need to know about federal estate taxes, and that's what's known as the unlimited marital deduction, which is really the greatest thing for making money, for the government, that is. You see, what the government says is, you can leave as much money to your spouse when you die as you want, and every dollar that you leave your spouse, you can use to reduce the value of your estate. Well, gee, Ted, you say, that sounds pretty good. What's wrong with that? Well, let's just say that we have a very wealthy individual, I don't know, maybe Howard Hughes, and he has $5 billion, right? And he's married at the time. He leaves everything to Mrs. Hughes. Well, what's the tax when Mr. Hughes dies? 0, right? $5 billion, and he gave $5 billion to Mrs. Hughes. There's nothing to tax when he dies. But what's the federal government waiting for? That's right. They're waiting for her to die. Because they know a couple things are going to happen. Mrs. Hughes is going to live for a period of time, and as she does, inflation will kick in. By the time she finally dies, there'll be more money in the Hughes estate than there ever was, and they'll be able to tax it at the highest possible rates applicable at that point in time. I refer to this very often as the unlimited marital deduction trap. And the reason I call it this is because virtually every married couple that has come in to see me before we've properly planned their estate would have fallen into the unlimited marital deduction trap. By that I mean they would have left everything, lock, stock, and barrel to their surviving spouse. I'm here to tell you today that if you plan your estate that way, you run the risk of paying far more in federal estate taxes than you ever needed to. And by the way, I'm not suggesting that we cut out your surviving spouse. On the contrary, I think that in most properly planned estates, the surviving spouse should have access to the entire estate for whatever they need. But it has to be done right, because if it's not, you're going to pay far more in taxes than you need to. And by the way, you cannot avoid the unlimited marital deduction trap after one spouse has died. You have to do it while both spouses are alive. Now, I want to caution you about a couple of things. The first is that if you don't have $600,000, you don't have any taxes. Well, that's not a real big caution, but what you do need to be worried about is that has nothing to do with the probate fees. You see, because living probate doesn't occur because of the value of your estate. It occurs because of the way you own your assets. And if you own things individually, you're stuck with living probate while you're alive and become disabled, or you're stuck with death probate upon your death. And if you own things jointly, well, it's worse for living probate now, because now you have a double risk of disability and living probate, and you have only postponed the death probate until the death of the surviving spouse. And I like to make a fairly strong point on this, because virtually every month I have someone comes in to me who was told by some professional that was advising them that they don't need to plan their estate because they don't have $600,000. Nothing could be farther from the truth. As a practical matter, 30 to 40% of my clients don't have a $600,000 estate. Why do they plan then? Because they want to avoid the probate. They want to make sure that they don't get stuck in a guardianship proceeding, and they also want to make sure that upon their death, their loved ones don't get stuck in court. So let me just impress upon you one more time. Living probate and death probate occur not because of the size of your estate. Living probate and death probate is concerned primarily with attorney's fees. Now, once the attorneys are all done, no matter what size your estate was, then the federal government's going to look at your estate if it's over $600,000. So remember that 7.4% that we were figuring for attorney's fees and probate costs? That's according to the probate. Now the taxes, that's what hits on those amounts over $600,000. I have plenty of clients who have well under $600,000 who do decide to plan their estates. Now, with either joint tenancy or the simple will, we know everything has gone lock, stock, and barrel from Bob to Pam. So Pam now owns everything. Pam is now a widow, and she has a $600,000 estate. You know, but you might say to me, Ted, you know, I really don't need to worry about my spouse living a long time, maybe like that fictitious Howard Hughes story, because I'm sure that my spouse would be so distraught that she would die, perhaps of a broken heart, within weeks of my demise. But in fact, that's not usually the case. Most of the time, a surviving spouse will live 7 years past the death of the first spouse. Why is this important? Well, it's important because whether you're planning your estate with our firm or with someone else, you need to project what's the value of your estate going to be at some time in the future. Because unless you're planning on dying today, the value in your estate today is almost immaterial. Now, let's say that in this situation, Pam continues to grow her estate at roughly 7%, and she outlives Bob by about 10 years. Well, accountants tell us that if we invest at 7.2%, well, in 10 years, the estate doubles. So in this case, Pam's estate has grown to $1.2 million. And then what if she becomes disabled? And like I said, this is one of the biggest problems facing America today. Many people would say it's one of the reasons we have problems in our healthcare system. The single biggest segment of the population that's growing today, do you know what that is? Those 65 plus. And these diseases affect us as our population grows older. We used to die before we got diseases like Alzheimer's or Parkinson's, but now we're living longer, and we need to get the medical technology to help us to help our minds live longer as well. Well, in this situation, who's going to manage Pam's property when she becomes disabled? Well, the joint tenancy, that's already gone, right? So the only type of plan that Pam would have had left would have been a simple will. And we know that a will can't help you while you're alive, so she's stuck with living probate. And who does the court pick as the guardian over Pam? The perfect child, Susan, or John? You know, John's a little bit older, maybe about a year, and in fact, I think he even cleaned up for this picture that you're probably looking at. The bottom line is the court doesn't have to pick either one of those, and the kids could spend a lot of their own money fighting over who should be the guardian, and the court might wind up picking somebody from the guardian ad litem's office, a perfect stranger. Well, this is going to go on for some period of time. Eventually, however, we assume that Pam dies. Well, what happens then? Well, since the only kind of plan that Pam had left was a simple will, then there's no distribution made to the kids until the estate is probated. Now, what did all this probate cost Bob and Pam? Well, if we take the national average, which is 7.4%, on Bob's first $300,000 estate, we calculate that as $22,200 in probate fees. Majority of it is attorney's fees. Now, by the time Pam died, the entire estate grew up to $1.2 million. That generates an additional probate cost of $88,800. We add those two together, we come up with $111,000. Now, even if you take out the $22,000 on Bob's death, if we assume that there was a joint tenancy plan, we're still stuck with $88,000 in probate fees. And what if you get a real bargain on it and you get them to do it for half the national rate? We're still looking at Bob and Pam's situation at $44,000 in probate fees. I ask you, is there any doubt in your mind why it is that you can find attorneys who are willing to write a will for you for less than $1,000? Less than $500. Well, it's 9 months after the date of death now, and the IRS man comes knocking on the door, and he says, Susan, we believe you owe us some federal estate taxes. And Susan says, federal estate taxes, what are those? You see, and he starts to do a tabulation. He says, you see, your mother, by the time she died, had a $1.2 million estate. Now, your mother had one $600,000 credit left, and we'll give you that. So we'll subtract $600,000 out, and we'll also allow you to subtract out your mother's probate fees of $88,800. That leaves you with $511,200. And Susan says, it sounds like a lot of money. What are the taxes on that kind of money? He says, $198,592. Oh, she drops over, and now they got another probate. No. So she says, how am I going to pay those taxes, and when do I have to pay them? He says, today. Yeah, federal estate taxes are due 9 months after the date of death of the surviving spouse. And they don't want your house or your cars. If you're in the farming business, they don't want your livestock either. What does the federal government really want? Cash. And how do you raise that kind of cash? Well, sometimes people have to sell things. Have you ever been to an estate sale or a garage sale? Do you expect to go there to pay full retail value for what they're offering? No. You're looking for a bargain. I think that's where 10 cents on the dollar was actually initiated. Well, and in fact, you know, if you happen to be heavily invested in commercial real estate, my guess would be that you wouldn't want to have to dispose of a piece of commercial real estate within 9 months and get fair market value for it. And yet, as we drive around the streets, we see plenty of commercial real estate for sale. I'm not telling you that it's all being sold to pay federal estate taxes, but no doubt some of it is. There's always somebody waiting around ready to pick up a bargain, right? It's kind of like there was a retail shopping store when if something was in the store for a week, it was half the price. Another week, it was half the price again. This is kind of what happens when people have to sell things under distress. Well, when we add in the probate costs of $111,000 to $198,592, we come up with total combined probate fees and federal estate taxes of $309,592. Now, even if we take out the $22,000 when Bob died, my guess is that that's still going to be somewhere between 20 and 25% of the value of the estate. Now, I'd like to go over some estates of some famous people, some people that you probably recognize. How about this one? Elvis Presley died with an estate of $10,165,000. His settlement costs were $7,300,000. 73% of his estate was lost to the evils of estate planning. We have John D. Rockefeller Sr., a $26 million estate. 26 million 9 actually, 17 million 1 total settlement costs, 64% lost to combined probate fees and federal estate taxes. How do we know all these figures? Well, because these were probate estates, and all these figures were subject to public scrutiny. Anybody could go down and look them up. Let's do a review now of what we've talked about so far, which is joint tenancy and a simple will. And the first one is avoiding living probate, okay? Now, can joint tenancy do that? No, joint tenancy is the worst possible item with regards to living probate, because you've got the possibility of both joint tenants creating a problem in living probate. What about a simple will? Well, we know that a will can't help you with living probate because a will can't help you while you're alive. What about death probate on the first death? Well, that is the one upside to joint tenancy, because everything does go to the surviving spouse. But if the surviving spouse dies 1 second later, 1 minute later, or 1 year later, we realize that all we really did was postpone the probate until the death of the surviving spouse. What about a simple will? Again, we know that if the will is being used to transfer the assets, we have probate. What about avoiding probate on the second death? Well, joint tenancy is gone at that point, so that we know that it's no help at that point. We're only left with a simple will, and we know again that a will is not going to help us with probate at all. What about avoiding federal estate taxes? Well, both joint tenancy and the simple will have us leaving everything, lock, stock, and barrel to the surviving spouse, right? And we know that you cannot save money in federal estate taxes if you do it that way. Now, before we move on any farther, I'd like to explain to you a little bit about gift taxes and federal estate taxes. And the reason is because they're really both the same tax. The rule goes something like this. You can give away $600,000 while you're alive or after your death or some combination of the two. But as soon as you go over $600,000, you pay gift taxes if you're alive or death taxes after your death. Well, why am I explaining this? Well, let's assume that I want to use a joint tenancy to give away, I just hit the lotto, right? And I'm going to give away $2 million to my kids in joint tenancy real estate that I own in joint tenancy. So I put my daughter on as a joint tenant. And does anybody know what happens the April 15th after I put my daughter on as a joint tenant on that $2 million worth of real estate? Well, I'm going to get a little note from the IRS. And they're going to say, Ted, you made $1 million gift to your daughter. The good news is I have a $600,000 exemption, so I'll use that, but I've still got a $400,000 gift, and I'd be required to pay somewhere in the neighborhood of $153,000 in federal gift taxes, and I am not going to be a happy guy. You know, I'll be even less happy when I come to realize that everything that I've now just put in joint tenancy with my daughter is subject to the creditors of my daughter and her estate. Now, what's the single biggest creditor besides the federal government that any one of our children are likely to have? That's right, it's their spouse. 50% of all marriages are ending in divorce. So if my son-in-law decides that he wants to divorce my daughter, he can try to enjoin the $1 million worth of real estate in that divorce proceeding. So at that point I might say, gee, give me back all of the property that I gave you. But that wouldn't be very good advice. And if I sought advice from an attorney, the proper attorney would tell me, gee, don't take that property back. And why is that? Because now my daughter would be making a gift back to me. Now my daughter would owe $153,000 in federal gift taxes when she gives me the property back. And what about when I die? Will I have any credit left when I die in terms of federal estate taxes to give property to my daughter? No, I will have used it all up during my life, and I'll pay federal estate taxes on the first dollar that I leave anyone after I die. Let's say that in this situation, Pam decides that joint tenancy would be a good idea on her house to keep it out of probate. So she puts her son John on as a joint tenant. Now she wants to sell the house. She says, John, I need your signature. And John says, Mom, my signature cost $5,000 today. Can Mom sell her house without John's signature? No. But you say, Ted, that's crazy. Mom had the perfect child, Susan. She would have put Susan on as a joint tenant. Well, let's say that she does that instead. Now, Susan's a joint tenant, and Susan's driving down the highway one day, and she swerves a little bit and knocks a school bus off the road. She now has 10 angry parents suing her for $1 million each. What just happened to half of Mom's house? It's gone. Come on, Ted. Susan would be a safe driver. Okay, let's assume that she is. Instead, Susan does something terrible, something unspeakable, something unforgivable. She gets sick. She gets so sick, She's in a coma in the hospital. Who's the judge in living probate protecting 100% of the house for now? That's right. She's protecting it for Susan. Mom has to wait for Susan to either die or come out of her coma before she can get control of her estate back. Come on, Ted. None of this would happen. Susan wouldn't go into a coma and she'd be a safe driver. Mom thinks this joint tenancy is such a good idea, she puts everything, lock, stock, and barrel, in joint tenancy with Susan. Now John comes up and he wants half of the estate. And Susan says, John, you've always been kind of a flake, and I'm not going to give it to you. And John sues Susan for his half of the estate. Who wins the lawsuit? Well, besides the attorneys, it's Susan. But Susan would do the right thing, you tell me, Ted. Susan would give John $600,000. So she does. She gives John $600,000, but what's she done now? She's made a gift, right? But the good news is she has a $600,000 estate and gift tax credit, so she doesn't have any tax to pay today. But what happens when she dies and Susan wants to leave the remaining $600,000 to her kids? Well, she's got no credit left. She'll pay somewhere in the neighborhood of $235,000 in federal estate taxes before that money gets to those children. What about John's kids when they get the money from John, assuming that he hasn't blown it all? Will they have to pay any federal estate taxes? No. You see, this kind of tax is imposed on the giver, not the recipient. Susan loses her exemption. And you see now, under the best case scenario, where everything happens exactly the way Mom wanted it to go, she winds up disinheriting her children through Susan to the tune of $253,000. We talk about joint tenancy passing property to an unintended heir. How many times have you heard of this situation? Husband and wife own everything in joint tenancy. One spouse dies, the remaining spouse owns everything. But then they get remarried again, and they put everything in joint tenancy with the new spouse, and then they die. But back here, from that first marriage, there were kids from 35 years worth of marriage. Did they get anything? No. And I guarantee you, when that first spouse died, they never intended that their children wouldn't get anything. That's what we mean when we talk about passing property to an unintended heir. You can't put planning instructions with a joint tenancy. There's no way to put any loving instructions with a joint tenancy. You know, what if I decide that I'm going to put money away for my kids' college education? So, gee, my son is 9 years old today, and I put $200,000 in joint tenancy with him. Now, if I die tomorrow, at what age is my son entitled to that money? Well, in Illinois, it's 18. And we all know, or at least I do, that my son will be very prudent at the age of 18. He'll get a good financial advisor, make great investments. He's going to college, he's going to graduate, and start a business. He's retired by the time he's 30, right? No, hardly. We were all 18 once, right? Investing and estate planning for an 18-year-old is very simple. You buy the fastest car you can. And if it's red, boy, you know you made the right investment, right? Okay. Now, before we move on to talking about living trust, I'd like to just mention to you a couple of things. As we move forward in the program now, I don't want you to assume that everything that I'm going to say is going to appear in every living trust done by any attorney. The fact of the matter is that we limit our practice to estate planning. So we're going to talk about some things. If we get together, we'll obviously be talking about these. But if you see something that I'm going to talk about now that's important to you, make sure you write it down. Because unless you're meeting with my firm, you're going to want to tell the other attorney that these are things you want to have in your plan. Please, don't assume that everything that I'm going to talk about automatically appears in your estate plan no matter where it's done. You see, the reason is because a trust is nothing more than a vehicle. And it's a vehicle made out of words. And there's more of these kinds of vehicles than there are cars on the road. You see, what you're going to do during your lifetime is you're going to take one of these vehicles, okay, and then you're going to take your property, and you're going to load it onto that vehicle. And then you're going to set that vehicle in motion. And during your lifetime, you're going to control that vehicle every turn of the wheel. But there will come a time when you can't control this vehicle anymore. Why is that, Ted? Well, that's because you've become disabled or because you've died. And at that point in time, the words that make up this vehicle, they have to be just right, don't they? Because if they're not, perhaps instead of the vehicle going the way you want it and distributing your property to your loved ones the way you want, perhaps it's going in another direction. Okay? A couple other things that I'd just like to mention about trust and estate planning. It would be my recommendation that you focus on doing your estate plan not with a general practitioner, but with an attorney that limits their practice to estate planning. There are far too many pitfalls that the unwary general practitioner can fall into. I was reading an article the other day that talked about the difference between two sets of words, continuing comfort and reasonable comfort. Now, that doesn't sound like a big deal. Yet to the IRS, it meant $1.4 million in additional federal estate taxes. And which is the right set of words? The point I'm trying to make is that you want to use somebody who knows which is the right set of words. The other thing that you should be on the lookout for, which I think is very dangerous, is what I call boilerplate trusts, or one-size-fits-all trusts. Those are trusts where everyone is exactly the same as the last one. Probably the easiest way you'll know if you've dealt with a firm that's planning on putting you in a boilerplate trust is when they quote the fee to you. And you might say, gee, Ted, how do you know that? Well, the reason I know that is because virtually, I'm going to say 1 out of 10 to 1 out of 15 clients that comes in to see me already has a trust. And so I ask them some questions, and one of those always is, when was the fee quoted? And undoubtedly, when I hear that it was quoted at a seminar, or within 5 minutes of the initial meeting, or without a full and complete consultation, we find that that person has a boilerplate trust. If you think about it, it makes sense, right? If they can quote you a fee before they know what you need, they're probably planning on putting your shoe or your foot into the same size shoe that they've been putting everybody else's foot into. Kind of like a shoe store, you know, that's got one size shoe and one color. Now, my guess is that everybody's got a slightly different fit. And if you deal with our firm, that's the way you're going to be treated as an individual. Now let's talk about a living trust. The problems that we encountered in terms of probate originally, we encountered because of the way we own our property. And right now, we're assuming that we either own our property individually or jointly, and we know that we have problems with probate when we own our assets that way. So the first thing we need to do is find another way to own our assets, and that way is a living trust. Now, this slide is going to become very familiar to you. You're probably going to see it about a dozen times before we're finished. And each time it comes on the screen, I'm going to identify another circle and another arrow and exactly what that means. And by the time we're done here, you'll know exactly what everything means on the screen. But for right now, let's just call this our trust slide. And what we're going to do is we're going to give this trust a name. And then what you will do is take all the names on your accounts and put your trust name on them. Well, what does that mean? That means that you don't own things in your own name individually, and you don't own them jointly. You own them as a living trust. And what you're going to find out is that a living trust, when it's properly drafted and well executed, doesn't have to become incapacitated when you do, nor does it have to die. Now, if you happen to be married, there's 3 positions in a living trust. Now, the first period of time is while you're both alive. While you're both alive, you have 2 living trusts. And the instructions might say something like this: take care of me, take care of my spouse, and take care of my dependent children. And if I can't take care of myself and sign my own name, then I want my spouse to sign my name for me. Or maybe my spouse and one of my kids, or a couple of my kids. Or maybe we don't think any of those people can make the decision, so we're going to go directly to a corporate trustee. That might be a bank or a trust company, somebody professionally to handle things. Now, the second period of time that we're going to deal with is when one spouse has died or while one spouse is alive. And now the instructions in the trust are going to say something like this: well, after I've died, I want my spouse to have access to the entire estate for whatever they need. But by all means, I want to save the most amount of money in federal estate taxes as I can. And again, we'll insert language that says, who do I want to sign my name if I cannot? And again, at this point, we might say I want my spouse and one of my kids, or a couple of my kids, or perhaps a corporate trustee. And then the third period of time that we're going to plan for is after both spouses' deaths. Now we're deciding, where is the estate going to finally go? Is it going to go to a child, a grandchild, a parent, maybe a charity, or someone with some special needs? And again, we're going to put instructions in there. Who do we together want to sign our names if neither one of us can sign our names by ourselves? And at that time, most married couples will say, I don't want to show partiality. I want all my kids to be able to sign my name for me. And then there's other people who say, gee, I don't think any of my kids are qualified to sign my name. I'm going to go directly to a brother and a sister, or maybe a corporate trustee. Now, if you happen to be single, there's really 2 periods of time that we plan for your estate. And the first period of time is while you're alive. The instructions are very similar. Take care of me. Take care of any dependents that I have. And who do I want to sign my name if I cannot? Well, if you're single, maybe you go to your brother or sister. One very common tendency that I see among single individuals is to go directly to a corporate trustee. My theory on that is that they haven't bothered anyone with their estate or their affairs during their lifetime, so they don't want to bother anyone with them after their death. The choice again, though, is completely yours. And then the second period of time for a single individual is what happens after death. And again, where do we want the money to go? To a child, a grandchild? And again, who do we want to sign our names? Well, again, we might pick up a couple of our kids or a brother and a sister, or maybe we go directly to a corporate trustee. The bottom line is, if you pick the people who can sign your name, then the court never needs to get involved in that decision. In a well-drafted, properly executed living trust, you take control. Now, I want to give you a few definitions that I'm going to use as we talk about trust. And the first of those is called a trust maker. What's a trust maker? Well, that's you. You're going to make the trust. You're going to decide what instructions you want to have in the trust. You'll tell the babysitter, if you will, exactly what you want to have happen. You will sign the trust, which means you make it. You're the trust maker. The second position of a trust is called a trustee. These are the babysitters. These are the people that follow the instructions that you made. And the third position of a trust is the beneficiary. And these are the people that get to spend the money. My guess would be that if you just had one choice, you'd probably choose being a beneficiary. Now, let's look at Bob and Pam's situation again. Let's rewind the tape of their life, and then let's create some trust for them, and let's see how much better their lives will be. Now, Bob and Pam met with me, and they said, gee, Ted, you know, we want to create a living trust. And so Bob and Pam met with me, and they said, you know what, Ted, we want to make this trust, so we're going to put all of our instructions in there, and we also are going to make all of our own investment choices, which means that we're going to be the trustees as well, which means that we're going to, if we want to buy stocks or bonds or invest in mutual funds, we'll do that as well. And we also want to be able to spend all of our money. And so we're going to be the beneficiaries as well. We're going to occupy all three positions of our living trust, Ted, because especially the beneficiary position, because when we want to buy that car or take that cruise, we want to be able to spend that money. So Bob and Pam occupy all three positions of their living trust. Why is this so important? Well, it's important because it really answers a lot of your questions in advance. Because if you ask me, gee, Ted, we don't know whether we want to build on that property that we have in Wisconsin or whether we're just going to sell it. After we make the trust with your firm, will we still be able to make that decision? Well, my answer will be yes. Anything you can do before you create the trust, you can do after you create the trust. We build trust for our clients so that they have total control over their estate. And they each have a living trust, and they transfer all their assets into that trust. Now, when they do that, there's no transfer tax. To be real honest with you, they're just moving money from one pocket into the next, and you don't get taxed for doing that. There's also no new tax forms. You file on the same Social Security number, and if you used a 1040 form last year, well, you use a 1040 form this year as well. And you can change this whenever you want. This is called a revocable trust or revocable, and that means you can change the instructions in this trust whenever you want to. What if Bob goes into a coma now? Will Bob be stuck with living probate, and will Pam have to be named the guardian? Well, the answer is no. Why not? Because Bob, during his lifetime, said, gee, while I'm incapacitated, I want Pam to be able to sign my name for me and to be able to take care of me. So Pam, if she needs to sell the house, she doesn't need to go into probate court. She doesn't need to hire an attorney, because Bob provided in his trust that he could do all those things while he was not disabled. And now that he is disabled, because his trust was properly drafted, he doesn't have any problems with those types of issues. So now, what happens when Bob dies? Will Bob's estate have to go through probate? No. And it's for exactly the same reason that it didn't have to go through living probate when he was incapacitated. Even though Bob died, Bob's trust lives on. And what did Bob say? He said, I want Pam to be able to sign my name for me. So Pam and one of the kids are taking care of all the business. If they need to sell the house, they can do that. There's no time delay because they don't have to go into any court proceedings. There's also no probate in any out-of-state jurisdictions as well, because we can take that out-of-state property and transfer it directly into your living trust so that your trustees can deal with those assets the same way as they could with anything else. On the death of the first spouse, there's also no federal estate taxes. In the sample that we're drawing up here, we've created a marital and a family trust, which utilizes all of the favorable tax treatment, which makes sure that no matter how big the estate gets, there won't be any federal estate taxes on the first death. And in fact, in this example, you'll find there is never going to be any federal estate taxes. Now, what happens when Pam becomes disabled? Well, Again, Pam had a trust, and even though Bob is now no longer with us, Pam made a long list of trustees, and she said, if I can't take care of things and sign my name, then I want my kids to be able to sign my name for me. Or maybe she named a corporate trustee. But in any case, it doesn't have to go into a court. So there's no time delay. There's no out-of-state court proceedings. There's no problem with Pam being taken care of, because in her trust she said, take care of me and take care of all of my beneficiaries. And furthermore, it's one of my preferences in trusts that I do for my clients to make sure that the family trust is protected from the catastrophic creditors of the surviving spouse. What does that mean? Well, that means that when Bob died, he left money in a family trust for Pam. Now, the money in that trust, with the right set of instructions, even though Pam might ride down the street and knock a school bus off the road, then those catastrophic creditors come chasing her. Well, they might take everything that Pam has, but they won't be able to take the amount that Bob left for her in the family trust. And that's what we call creditor protection. These are the kind of things that we don't typically see in boilerplate trusts. Okay, so now what happens when Pam dies? Well, on the death of the second spouse, again, there's no probate. And why is that? Well, because Pam also named a set of death trustees, and those are her kids, so they can handle things without attorney's fees, without court costs, without any public hearings, and again, no probate on out-of-state property. And furthermore, upon the death of the second spouse, federal estate taxes are lowered. And in this example, we double the tax exemption from $600,000 to $1.2 million. You remember the story. The IRS man comes knocking on the door. He says to Susan, "Excuse me, Susan, but we believe you owe us some federal estate taxes." And she says, "Oh no, we don't owe you any federal estate taxes." He said, "You must. Your mom had a big estate." And she begins to explain to him, "You see, my father, Bob, before he passed away, he had $300,000 that he put into his trust. Now, when he died, my dad's trust said, put all that money in a family trust. Did it say give all the money to my mom? No, that would have qualified for the unlimited marital deduction trap. No money went directly to mom, it went into a family trust. But mom was the beneficiary of that trust. That means she could spend the money on that trust for whatever she needed. But you know what? She didn't need it, and mom was a good investor. She invested that money, and by the time mom died, there was $600,000 in that family trust. And that comes down to us kids. You see, my dad has a $600,000 federal estate tax exemption." And the IRS man says, "Well, that's okay, but what about your mom's trust, Pam?" He says, "Well, yeah, mom had $300,000 in her trust on the date of dad's death. She was a good investor with that money, too. It grew up to $600,000. And where does that money go? Well, my mom's trust says that that money comes down to us kids. And excuse me, Mr. Taxman, but what's my mom's federal estate tax exemption? $600,000. And so you see, we get you what you're entitled to, and that's a full $1.2 million exclusion from federal estate taxes. It's there in the tax code for you to use, just like mortgage deduction on your house. The problem is that a lot of people don't take advantage of it. Now, the trust can survive you, and how can it benefit your loved ones? Well, for instance, it can benefit minors. How can it benefit a minor? Well, we might create a common trust. What's a common trust, Ted? Well, that's like a common pot where we keep all the assets together. And we keep those assets together usually until the younger one gets the same benefits as the older one. For instance, let's say that on the date of your death, you just finished college educating your 24-year-old child, but your 18-year-old child hasn't yet started college. Well, would it be fair to split that money in two and make the younger one pay for their college out of their share? Probably not. We'd probably be better off keeping that money together in what I like to call a soup pot trust, where it stays all together till the younger one reaches the age where they're finished with college. Now, we're not out to make professional students, so we'll also probably put some age limitations on there as well. We can also protect elderly individuals. One of the most dangerous things that you can do is leave money to somebody that's older than you. Because let's face it, if they get that money, the chances are they're probably going to die shortly thereafter because they're older than you. And the chances are we've just taken money from your estate, which was not taxable, and now maybe we've put it into somebody else's estate who's going to die very soon, and it'll be taxable before it goes to probably your children. So what we generally want to do in a situation like that is create a separate trust so that if mom or dad needs some money out of that trust, they can take a little bit out. But we know that they're probably not going to need it, and when they die, it can all go to our children. We can save very often more money in federal estate taxes that way on the death of a parent or a child than we can even for the parents while they're alive. We can also protect this money from the special needs for perhaps a handicapped child or someone who has some special needs. Do you know two things that happen if you leave money to a child who has a handicap? Well, the first thing is, the state takes what they call reimbursement. See, they've been keeping track of everything they've been spending on your special needs child, and they're going to take out of the inheritance everything that they've spent on your child. And then if there's any money left over, that might actually disqualify them from further aid, and they'll wait till the money runs out before that child will qualify again. For people in that situation, we make sure we set up a special needs trust where the state can't invade the money for reimbursement, and so that they also won't disqualify that child from the aid that they're receiving. A little bit of money in a trust like this really goes a long way. We can also protect this money from, children like John, somebody who's going to squander it, a spender. If you're convinced that the only way your child is ever going to retire is because you've left them an inheritance that they can retire on, well, then maybe you want to structure that inheritance so that they don't get it until they're 65. And then maybe they only get the interest, or maybe just portions of it to last them over the next 20 years. We're going to chunk it up. Millions of different ways you can benefit the individual needs of the individuals that you're leaving the inheritance to. Because let's face it, an inheritance can often be a curse if it's not left the right way. We can also protect the money in these trusts for your kids from their creditors. And what's the single most likely creditor any one of our children are likely to have? It's their spouse. That's right, 50% of all marriages end in divorce. And so what we can do is we can put money in a special trust so that our child can get to the money, but if they ever get divorced, it doesn't go out, half of it out the door in a divorce proceeding. That's what we call creditor protection. That can also be very effective if we've got perhaps a physician or an attorney in the family, and they're afraid about medical malpractice or legal malpractice, or they're afraid that they might get sued and have everything taken from them. Let me ask you this, and think about this. If you were a child of your own and your parents had left you money in a trust, and you knew that as long as you left it in that trust, it couldn't be taken by a divorcing spouse or any other creditors, but you could take it out if you needed it, would you ever take the money out of that trust? Well, probably not unless you needed it. You'd probably spend your own money first, because the money that you have in your own pocket, that's not protected from your creditors. What does that mean? Well, that means that these trusts can last a long time. They could last the life expectancies of your children very easily. 50, 60, 70 years. Perhaps even the life expectancies of your grandchildren, 70, 80, 90, or 100 years. What if your trust does survive you by 100 years? What kind of instructions would you want to have in your trust? I'll tell you what's a better way for me to think about it. What if a trust was created by my ancestors 100 years ago? What kind of instructions would I have wanted my ancestors to put in that trust? My guess is that I'd like to have my ancestors take the proper time and care to make sure that that money never got taken by any of the creditors of my ancestors, never got taken in a divorce suit. In short, I want to have made sure that my ancestors took the proper care to make sure that some of that money was still there today. The last thing that I want to present to you here is what I call a trust portfolio, and I'm just going to go through this briefly so you'll get a feel. This is the way we package an estate plan for our clients when they're finished, and the reason that we do this is so that you have everything together in one place. Now, there's a few critical things that are included in every plan. One of them is a table of contents, so that you know exactly what's inside each section. There's an introduction page here as well. Now, this section here is the living trust, and in fact, in this particular sample, this is a living trust. And an average living trust for our clients is going to be somewhere between a ½ inch in thickness and an 1¼ inch. You can't plan an estate properly on 5 or 6 pages or even 10 or 12 pages of one-size-fits-all boilerplate. Now, on the last couple of pages of the trust, you as a trust maker will sign, and I'll go ahead and notarize your signatures for you as well. Now, there's a few other things that you need beside the living trust, and one of the things that we give you is called a power of attorney. Now, a power of attorney is there just in case you become incapacitated before you have a chance to fully fund your trust. Funding the trust means putting the name of your trust on all of your assets. Now, if you haven't had a chance to do all that and you become incapacitated, I've got one of these written for every one of your trustees so that they could fund your trust for you. Now, when you go in to change one of the names on your accounts into the name of your trust, you don't need to bring a copy of the whole trust. It's a private document and you want to keep it that way. Although many attorneys would require you to do that. What we give you instead is called an affidavit of trust. And an affidavit of trust is simply a document that says, this is my trust, I have one, and here's a couple of pertinent pages from the trust. The rest I'm going to keep private, but this is the name that I want you to put on there. And so when you go in to change the name on your checking account, you just hand this to your personal banker, and they'll take care of that for you. We also give you some things that aren't technically estate planning documents, but we think everyone should have one. And one of those is a healthcare power of attorney. Healthcare power of attorney, this statute was enacted after 3 or 4 revisions by the Illinois State Legislature, and they finally came up with one that works. And what this basically says is, if I can't make medical decisions for myself, then I want my wife or whoever I designate to make those decisions for me. The nice thing about it is, then you don't have to be worried. If your desire is not to be kept alive in a vegetative state, you need to have one of these healthcare powers of attorney. By the way, this is not a Dr. Kevorkian document. All we're talking about here is legitimately allowing your wishes to be carried out. We also have what's called a living will. Now that follows an older statute in the state of Illinois, but it's still valid, so you have one of those. This is limited to irreversible and terminal situations. So if you would not want life support to be continued under those circumstances, you'd certainly want to have a living will as well. I also provide you with a pour-over will. You may have heard about a pour-over will. What this is a will that acts as a safety net to catch anything that may not have gotten into your trust during your lifetime. And then what it does is it pours it on over into your trust, hence the name, pour over will. But in actuality, I hope it's a document that you never need to use because it's a will. And if you need a will, where does it have to go? Right, into probate. And we want you to stay out of probate. This is here only as a safety net. By the way, when I deal with clients who have a boilerplate trust, very often when I ask them if they have the trust funded, they tell me no. When I ask them why, many of them tell me it's because the attorney told them that the pour-over will would get everything in there when they die. Well, I don't know if that's just because they don't have a funding department or exactly what the reasoning is behind that. But all I know is that we have an attorney on staff that makes sure that all of our clients, when they need help funding their trust, get the proper help. And that's always included as part of our fee because we want all of our clients to stay out of probate. We have a location list here as well, which helps you to keep track of all those important documents in your estate. It's sort of like a checklist. You write in where you keep these certain things, and the nice thing about it is that now you don't need to tell the kids exactly where everything is. All you have to do is tell them where the binder is. Once they find that, they'll be able to find all of your important documents. Once you transfer something into the trust, you'll go to the trust transfer documents section, and you put a photocopy of it there. That way the kids will know what did they put in mom's trust and what did they put in dad's trust. I give you a section here where you can keep track of your life insurance policies. The next document is called a memorial letter. And what this does is it makes it a lot easier on your loved ones when you're gone. What we start you out with is a letter to your loved ones, and on the bottom you write down what you want to have happen in terms of funeral and burial arrangements. So if you want a New Orleans style funeral, you want a band marching with you, you can tell the kids that. In all seriousness now, we know that a lot of problems are happening in families because there's arguments over, what color the flower should be and what kind of casket there ought to be. Put down your instructions and there never needs to be a problem in your family with regards to that. We also have an anatomical gift form. If you're an organ donor, we can make sure that your wishes are backed up within your trust portfolio so that if anybody's wondering if in fact that's what you really wanted to do, then in fact you'll have it substantiated here. We also provide you with a document here which basically allows you to give personal property to whomever you want, and you can change your mind on these things whenever you'd like. So let's say that you have a favorite clock, and you know that your daughter really had her eyes on that clock. Well, the nice thing is that you can come in here into the personal effects section, and you can take what's called a memorandum for distribution of personal property. Now all the directions for filling this out are right here, so you can do this anytime you want without an attorney. You put in your daughter's name here and you put in that clock that you know she always had her eyes on, then you sign that in front of 2 strangers who witness it. The great thing about it is that if she comes over one day and says, Mom, I always hated that clock, you can take this out of your portfolio, rip it up, and you can give the clock to somebody else. You don't need to call our firm or any other lawyer to change your mind on that type of thing. It's everything that you need to completely plan your estate. Now, because you've taken the time to watch this video presentation, I make available to you with our firm an initial consultation, which is at no cost. Now, you should allow probably 2 to 3 hours for that meeting. And what we're going to do during that consultation is, first of all, we'll review your current plan. So if you have a will or a trust, bring it in and we'll take a look at it for you. But what we'll also do is we'll estimate your probate costs and your federal estate taxes, but more importantly, we will get to know each other. You will teach me about yourself, and I will teach you about trust. And then together, we'll design instructions to uniquely meet the needs of you and your family and your estate. And by the time we're finished there, it's really not a dry run. We'll have all the information we need to put a plan in action for you if you want to do that at that time. We'll also be able to tell you when we're completely finished, we know exactly what we're going to do, exactly what it's going to cost. If you want to get started at that point in time, we'll be able to show you how to get started. My goal during that meeting is to get you better informed with regards to estate planning and living trust than you've ever been before. One of the ways that I'm going to do that is by answering all of your questions, because it's only by completely seeing how the plan is going to be put together, and we're probably going to draw some charts and graphs and make it look real nice, and we'll answer all of your questions, because it's only after you know exactly what it's going to look like and all your questions are answered that you'll know whether or not this makes sense for you. Now, in this presentation, we covered estates up to $1.2 million. I want to let you know that no matter how big your estate gets, we can properly plan it. And our goal is 0 estate taxes for all of our clients. And very often, just by repositioning some of the assets, we can accomplish that. If your estate is over $1.2 million, we probably put you in an advanced tax planning meeting after we do the core of your living trust estate plan. That advanced planning meeting is also at no cost to you. When we're finished, if you decide to take some of our recommendations, we'd be able to tell you exactly what the fee would be. You make your choice at that point in time. Also, when you come into the initial consultation, if you're married, you need to be there with your spouse. We find that it's much more beneficial when both spouses have input, and as a matter of fact, we really can't do an estate plan for somebody that's not there. So please make sure if you're married that you get there with your spouse as well. If for some reason you need to cancel or reschedule the appointment, please give us at least 10 days or 2 weeks advance notice. As a practical matter, once you schedule your appointment, you'll basically get a questionnaire from our office. It takes about 15 minutes to fill out. It's almost impossible for us to find another person to fit your spot and get the questionnaire out to them and get them in. So what you wind up doing is leaving us with a dead spot on the calendar. So be considerate. If you do need to reschedule an appointment, give us enough time. We know that's not usually a problem, but we do like to mention that. Probably one of the most important things. I guarantee you, when we leave that meeting, a couple of things are going to happen. Number one, I will have learned something. I live my life by the policy that you can learn something from everybody you come in contact with every day. But more importantly, when you leave that meeting, I want you to be richer for the experience as well. And I want you to feel that you also have learned something from being in contact with me. Whether you decide to become our client or not, I want you to leave our office knowing that we would do the best job for you and that you would feel comfortable recommending us to any of your friends or relatives, or maybe you'll come back to us sometime in the future. At any rate, whether we leave that meeting as just friends or friends and also attorney and client, I look forward to meeting with you. If you remember just one thing from today's presentation, remember this. You don't just do an estate plan for yourself. You do it for those you love. And for me, that's my family. I'd like you to meet them. Thank you for taking the time to view today's presentation, and I look forward to meeting with you real soon.